All right. Good morning, Internet. Good morning, everyone who is attending this webinar. I am Eric Peters. I am a partner in Verrill's Labor and Employment Department. I'm joined today by my colleague, Liz Johnston. Good morning, Liz.
Good morning, everybody.
All right. We are here to tell you a little bit about conducting workplace investigations. And essentially what we're going to be doing today is walking you through how to conduct a successful workplace investigation, processes you should follow, tips, things to avoid, and various other considerations that you're going to want to factor into your investigation. A couple of housekeeping matters before we get started on what is a pretty well jam-packed presentation. For those of you who aren't familiar with Verrill's webinar series, we record the actual webinar and email it to you along with a copy of the slides, and that'll be in the next couple of days or so. If you have any questions, we heartily encourage you to submit them. Those of you who present on a regular basis know that that really makes things a lot more interesting. And frankly, if you've got a question, it probably means that at least one other person has it. So please go ahead and submit those questions, enter them in the Q&A box. We will do our best to answer them in real time given the technological limitations that I have. All right, with that said, let's get started. And we want to kind of start at the end. Theory of if you don't know where you're going, you'll never get there. What's the goal of every workplace investigation? That people think it's fair and objective and thorough. And the way that I look at it, when I'm questioning people, I usually will say this when they ask me, you know, where are things headed here, or what do you think? I mean, I generally won't provide any substantive impressions, but I say something to the effect of, in all likelihood, 50% of the people participating in this investigation are going to get it wrong. The person who is accused of doing something generally does not believe that he or she has done so. And if you find against the accuser, they're not going to be happy either. So knowing that going in, my goal and your goal as an investigator should be that the perception and the actuality of your investigation is that you conducted it thoroughly, you did so objectively, and you did so fairly. And that way, even if people disagree with you, they can't disagree with the effort that you put in to get to the result. All right, so let's talk about some common scenarios that lead to workplace investigations, and you can see these up here. You got an actual crime committed or some illegal behavior where there occurs some theft on the company's property or a fight. You've got a rumor of something like that, third-party complaint. Many of you know that as employers, you can be responsible if one of your employees harasses a third party, like an employee harassing a customer, for example, or a customer harassing an employee. You have the duty to respond to that and potentially investigate it. At the bottom, you can see what is sort of the bread and butter of our practice, allegations of sexual or other types of harassment, racial, religiously based. We see a lot of disability based. We're starting to see more of allegations that someone was unfairly denied a job or promotion that they were entitled to based on a protected characteristic. You didn't promote me because I'm a woman, because I'm gay, because I'm from the Middle East, anything like that. Retaliatory actions are always a big one. In fact, for probably about the last 15 or so years, the EEOC, Equal Employment Opportunity Commission, the federal agency that enforces federal anti-discrimination laws, has tracked lawsuits and charges of discrimination filed with them, and retaliation has been number one for something like 10 or 15 years straight. Some other common scenarios are violations of the law. I think many of us have had to face allegations where people come in after the fact and say, hey, I was working off the clock, you knew about it, you owe me money. And then there's kind of the granddaddy of them all, which is when you get an employment discrimination claim filed with the EEOC or for similar state agencies. Up here in Maine, that's the Maine Human Rights Commission. We are licensed, our attorneys are licensed in various other jurisdictions. I'm licensed in Massachusetts and Connecticut. For those of you who are in those states, you're probably more familiar with their administrative bodies, the MCAD and the CHRO. All right, that's kind of a brief overview of how things often get started. I'm going to hand it off to Liz, and she is going to talk about some considerations that you need to be mindful of as to whether and when to investigate.
Thanks, Eric. So one of the primary reasons, the main reason really, of setting forth an investigation is to figure out what happened. We talked about, Eric talked about some of the reasons you might investigate. Many of those, unfortunately, involve employee misconduct. So if there was employee misconduct or allegations of misconduct, as an employer, you want to determine whether disciplinary action might be appropriate in that circumstance. This serves two purposes. One is specific to the employee, a deterrent or punishment essentially for the misconduct that occurred, but also it helps set a precedent for issues that might happen in the future. If somebody else engages in similar actions or similar misconduct, the investigation and the result of that in a disciplinary sense can help set a baseline and sort of a comparator situation for an issue that might come forward in the future. And that can be helpful if there ever is future litigation involving that other disciplinary action. Another reason that you might want to investigate relates to management and figuring out if management made a mistake or had an oversight. As an employer, you rely very heavily on your managers to keep your operations running smoothly, help with employee relations, maintain your organization's reputation. And a big part of management's responsibilities is to model and enforce your policies. So you'll want to determine if there was a management issue or a mistake that was made so that you can resolve that and deal with that appropriately. Another really important reason, and the reason that a lot of situations sometimes end up in the Maine Human Rights Commission or court, is if there's an issue of harassment, retaliation, or discrimination, or an issue like that. So great reason to investigate if you have a suspicion or an allegation that an employee or a manager has been involved in any activity that would violate the Maine Human Rights Act, Title VII, or any other law prohibiting illegal discrimination. Those claims can carry very significant liability if they are not addressed and end up in a claim. Going back to the management aspect of this as well, and Erik referenced this, I believe, but your manager's knowledge can be attributed to your company. So if there is a harassment or discrimination issue going on and management, or just even a single member of management, is aware of that activity, even if they're not participating in it, the company can be liable for that knowledge because it can be attributed to the company itself, and that can really hurt if there was ever a claim in the future.
And let me jump in for one thing to build on what you just said here. One of the things that we see a lot in our cases that do end up in front of the Maine Human Rights Commission or one of the other agencies I mentioned, or in court, is this allegation that hey, I didn't report this harassment for a while, but you should have known about it. It was so blatant, it was so out in the open, or your managers were right there, they saw it. So it's a little bit beyond the scope of what we're talking about today, but any of you who work with employment law attorneys know that, along with documentation, we love training of managers, especially frontline managers who are boots on the ground, who are going to be the first people to see these types of things and respond and bring it up the chain of command and say, hey, this may not be anything, but I heard X, Y, and Z. I'm going to reach out to so-and-so to ask them if there is a problem. That can be the kind of thing that makes a difference between a court or an investigator with the Maine Human Rights Commission finding, well, hey, he or she didn't report the harassment to you officially or through official channels rather, but you should have known about it.
Definitely, no, it's a great point. And another piece of that, that we've seen is in some cases, particularly with harassment and discrimination, it's sometimes the issues aren't as singular or much of a one-off situation as they might initially appear. So in terms of, the purpose of an investigation being to figure out the facts of what happened, oftentimes an investigation can reveal more widespread activity. Maybe comments weren't just made to a single employee. Maybe it's been going on for a lot longer than anybody knew about or reported. But an investigation can really help, reveal those more widespread issues that might not just be the singular target of the investigation.
Point.
So, many times we've referenced potential litigation, but that can be a very, very long time after the actual issues occur or the investigation itself. So, Maine human rights claims, for example, can be filed up to 300 days after the alleged act of discrimination. It can take months or even a year to get through that process, and litigation can drag on for years beyond that. So you can imagine how difficult it would be to try to remember tiny details of conversations, the timing of conversations during the day, series of events, who was involved from things that happened years ago. So one of the benefits of an investigation is obtaining witness statements and getting that information in a time near the actual events, because it can help solidify the details of what happened and memorialize those, so that if anything was to happen litigation-wise, everybody's not trying to recreate from memory what happened way down the road. You might need people who are involved to be involved in a deposition or in responding to discovery, or hopefully not, but maybe participate in the trial. So it's a great way to sort of memorialize what happened at the time close to the event. We'll talk more later about privilege issues, particularly whether you want to have an attorney involved in the process of the investigation. But if you are doing an investigation yourself without any counsel, you should expect that your materials and your results of your interviews will be produced, or will need to be produced in discovery, so turned over to the other side if there ever was litigation. So that's why we do encourage working with counsel to help navigate those issues and at least work through them to see what might be most appropriate in a particular situation. Final issue is, a reason you might want to investigate is related to what we call the Farragher-Ellerth defense. So this is an affirmative defense that's meant to protect employers that take reasonable steps to help resolve workplace harassment issues. When we say an affirmative defense, what that means is that it's something the employer has the burden to prove on their side. So in cases where a supervisor is engaging in misconduct or harassment, specifically creating a hostile work environment, the employer can assert this defense to help avoid or mitigate liability in a lawsuit. Oops. So this defense came from two Supreme Court cases, United States Supreme Court cases, back in 1998. They came out on the same day, as they were sort of joint opinions in a sense. And essentially the court held that an employer can be liable for a hostile work environment created by a supervisor over an employee who is the victim of that behavior. And the cases established that affirmative defense, and there's two elements to it. First is that the employer exercise reasonable care to prevent and correct promptly any sexually harassing behavior or harassing behavior, and the employee unreasonably failed to take advantage of preventative or corrective opportunities from the employer. So the investigation process really goes to that first element. It shows that the employer's taking care to prevent and correct harassing behavior that occurred. It also shows the employer's efforts in finding out what happened or what's happened, making sure it doesn't happen again, and taking steps to make sure it doesn't happen going forward with other folks. So investigation would be really helpful to that element.
And one other thing related to Ellerth, Farragher, and this issue of correcting promptly. Thank you. Correcting promptly and trying to prevent any sexually harassing, but also racially, religiously based. There's not most of us who've been involved in these types of claims know it's not strict liability. It's not, hey, I was sexually harassed, so the employer's automatically liable. But a more kind of nuanced point regarding that is that even when an employer knows about, let's just use sexual harassment as the example. Even if it happens again, the employer in certain situations is not automatically liable there, as long as it's taken steps to correct promptly, and that's the verbiage from the cases, the harassing behavior. And a lot of times, and again, the investigation can also help establish that, which is, hey, we understand that you are claiming that you were harassed even after you gave us notice of what was going on, and even though we tried to prevent it, but we did try to prevent it. And in that situation, what a court or an administrative agency is going to look at, or should look at, is whether the employer's response to the harassment was reasonable. And generally speaking, if you've got a workplace investigation, a legitimate one that was done, that was done correctly, that was done objectively, that was done fairly, and that was done promptly, even if harassment subsequently occurs, it can help you avoid liability. Again, even if there is this subsequent harassment. So that's kind of another secondary point to asserting the Ellerth-Farragher defense as well. All right, let's switch gears just a second, and let's talk a little bit about who should investigate. So internal versus external, we mean, should it be somebody with the company, typically someone in HR? or should it be someone external to the company, like an attorney or a private investigator? In a lot of states, including Maine, I mean, you can see the statute, the site to the statute in Maine up there on the screen. External investigators, the individuals who can conduct external investigations are limited to certain people, and that includes private investigators and it includes attorneys. But generally, that's not the case with regard to internal investigations. To a degree in terms of credentials, it doesn't matter who conducts the internal investigation, although we're going to discuss in just a second that it really does matter substantively who conducts the investigation. But once as part of the decision of should someone from inside the company versus somebody outside the company, an attorney or a private investigator, look into what's going on, we want to run through a couple factors that you should consider. And I know in my practice, this comes up a lot. I had a client a couple years ago, it was a gastroenterology practice, and they had about, 75, 80 employees. And they were between HR directors when someone complained about sexual harassment. And I came in and I did an investigation on their behalf, and we resolved the issue. They subsequently hired somebody to serve as their HR director. And over the next couple of years, I worked with that person behind the scenes to handle some investigations that he actually did. I was essentially there as a resource. And we frequently serve in both roles, actually conducting the investigation or being behind the scenes so we can help with any questions or anything like that. As part of this kind of behind the scenes role at the beginning, we work with a lot of our management side clients to look at, the basic question of should it be us or should it be you in terms of doing the investigation? And you can see on this slide and the next one, there's a couple factors that we typically look at and that most employers look at. How big of an investigation are we talking about here? Is this, relatively simple, or is this something where, it's going to take a couple months and you're going to be interviewing dozens and dozens of witnesses? For example, I did an investigation a couple of years ago regarding allegations of a hostile work environment being created by the CEO of a company. And I ended up interviewing, I think it was 35 witnesses between Thanksgiving and Martin Luther King Day of the following year. And that was one where we knew there were a million people that wanted to talk, both pro and con, for this employee who was accused. And so that was one where they knew going in that they were going to need somebody external, and they retained me. You can see the next bullet is a perception issue, and by fixed, we mean biased. And so if you have someone internal to the company, is the perception and potentially the reality going to be that they were biased either in favor or against the accused? So for example, let's take this HR director scenario I mentioned just a second ago. Does the HR director, the internal investigator, have a history with a witness, involvement in the matter being investigated? Did they look at it before it was determined that it should be a formal investigation? Do they have a history with the accused? Do they have a history, either positive or negative, with the accused, with the accuser, with people that are going to be key witnesses? Is a higher level management side employee involved? Is the HR director going to be investigating his or her boss? Obviously, if it's something like that, it just doesn't look good. And if I'm I'm an employee and I'm investigating somebody who's got the power to hire or fire me, whether there is an actual bias or not, there is going to be this perception that I was in the tank for this person because I knew that he or she could end my job if I came up with a conclusion that they didn't like. You also need to look at, in terms of the internal versus external decision, does the person internally have experience conducting investigations? It's not, you don't necessarily have to be certified by the American Association of Workplace Investigators or anything like that, but it's like anything else. The more you do it, the better you get. And then you have to look at, do they have the right skill set? Are they a good listener? Do they relate to will they be able to relate to the witnesses? With investigations, and this is something that I see a lot as an attorney, especially somebody who does litigation like me, it's a different style of questioning of the witnesses. It's not, you can't just hammer somebody like you would at a deposition or a trial to get them to answer your question. You really have to draw them out and build some rapport and, really have good communication skills and good listening skills in order to elicit the information that you're going to need to conduct an effective investigation. And frankly, not everybody has those skills. And not, I don't say that meaning that you have to be an attorney to do it. Not all attorneys have that skills. Most investigations of any great scope tend to end up with at least some kind of written work product. So one thing you have to look at in terms of internal versus external investigators is the person internally who may be conducting the investigation a good writer, or do they struggle with written communication? Finally, another factor is, are they likely to be an effective witness if they are questioned about their investigation? And that's kind of two concerns, at least. One is, are they going to, if they could be the greatest witness in the world, but if the investigation is garbage, that's not going to matter. Or they could be the greatest witness or they could write the greatest report and conduct the best investigation in the world. But if they can't express themselves, if they can't describe the processes that they went through, the evidence that they considered, both pro and con to their conclusion, that's not going to, they're not going to stand up well under cross-examination at a deposition or if the case goes to trial. All right, so related to what we've just been covering, should an attorney investigate? As Liz indicated a moment ago, a lot of times there are issues with attorney-client privilege. I essentially assume that everything that I write, any communications that I have when I'm conducting an investigation, will be given to all parties, both sides, if a case goes into litigation. That case I was talking about when a couple of years ago when I interviewed, felt like every day of my life between Thanksgiving and MLK Day, I was doing a witness interview. My client requested that I was retained by the company, and they requested that I update them, not substantively, but regularly, about the progress of the investigation. How many people have you interviewed? Who have you interviewed? How close are we to getting done? Things like that. And I told them that I would be happy to do that. But I also told them that I was going to update the lawyer who was representing the accused, and I did. And I would, if I communicated by email, I would send an email to them, and I would essentially send the same email to the lawyer for the accused right afterwards. If I did it by phone, I would typically have a call with my client, the company that had retained me. I'd hang up the phone and I'd call the accused counsel right after that. And I would document that I had done all of that. And that goes back to my statement at the beginning of this, that you need to have your investigation be fair and perceived as such, and objective, and obviously thorough and unbiased. Other considerations about whether you should have an attorney investigate. Do we think this is headed to litigation or not? If so, a lot of the concerns I mentioned a second ago, especially about whether someone's going to be a good witness or a liability on the witness stand, are heightened. Is there serious criminal behavior involved? The more serious the matter, obviously, the more you should think about having someone outside of the organization who doesn't have ties to the company investigate, like an attorney. And also, does the investigation involve somebody who's senior in management, like a CEO or a COO? Just, again, perception can be reality a lot of times in these situations. So it's really important not only to be objective and unbiased, but to be seen as unbiased and objective. All right, I'm going to hand it back over to Liz, and she is going to talk a little bit about starting the interview and some interviewing techniques.
Eric, this is actually yours.
You can tell we're crack organization here. All right, one more. So getting started before the investigation starts, what do? I said earlier when we were getting started that if you don't know where you're going, you'll never get there. What's the investigation scope? What are we looking at here? When I am assigned to conduct an external investigation, as part of the retention letter that I send a client that has all the stuff about my fees and retainers and how the relationship is going to work, I tell them this is what you have hired me to look at. And while I will kind of go where the facts lead me, there's a phrase in workplace investigations called scope creep. And that is, well, I was hired to look at A, B, and C, but in the course of doing that, I learned about D and F. So I will try to, stick pretty narrowly to the scope of what I've been asked to look at. Obviously, I'll consider everything that's in there. But what I will do separately is I will point out to the party that's retained me, hey, you hired me to look at allegations of sexual and racial harassment going on with the management team. By the way, I found some evidence of, that there was some self-dealing, some embezzlement, whatever. I'm not looking at that right now, but I'm telling you that this is what I found. Do with it what you will. If you want me to investigate that separately, I'm happy to do so. And look, related to the investigation scope is clarifying what exactly am I answering here. So in this harassment case that I've mentioned a couple of times, it was, did the CEO of the company create a hostile work environment via her conduct and statements? Pretty, very, very simple question that I was answering. But again, it took me 36 witnesses to get, and 2 months to get through it. I also like to outline the applicable standard of proof, which Liz and I do civil litigation, and what you see there with the preponderance of the evidence, that is typically the standard of proof in civil cases, that something is more likely than not something happened. It's more likely than not that someone harassed somebody else. It's a greater than 50% chance is essentially what that means. I look at facts, not legal conclusions, and not the consequences. Okay, the way that I like to describe things is only a man or a woman in a black robe or a jury can say whether hostile work environment or whether legally cognizable retaliation occurred. But I can talk about what the standard is. This is what a hostile work environment claim involves. And I can say what happened here, but I won't say, in my estimation, a hostile work environment was created for using that example. And I also, generally speaking, will not talk about what consequences should result from my conclusions. Hey, so-and-so should be fired. So-and-so should be given a 2-week suspension without pay, that kind of stuff. To me, that's management's job. And I, generally speaking, am not asked to opine on what the consequences should be from what I've concluded. Okay. All right. Now I'm going to turn it over to Liz, and she is going to talk about how to get started in interviewing people.
Thanks, Eric. So let's jump into starting the investigation. So off the bat, I just want to say preparation is really key to having a successful investigation. There's a saying that if you fail to prepare, you prepare to fail. And I think that's particularly relevant when you're doing a workplace investigation. So let's talk about some of the ways that you can prepare to succeed. So first, outlining your relevant policies and personnel file materials. If you have particular policies that are potentially being violated here, or particular employees that are involved, it's helpful to have an understanding of what documentation you have of those issues. Particularly if you have an employee who's alleged to have engaged in some harassing or discriminatory behavior or other misconduct, you want to think about, has there been any prior issue that's similar to that or different from that? Has there been any prior discipline that's been administered? If more than one person's involved in the investigation or in the situation that's being investigated, have there been any issues between those individuals? Is there anything in their files that would give you some background or insight into the issues that are being investigated? How do the parties relate to each other within the organization and the structure of management? So all of those types of all that type of information can be really helpful to sort of know and outline at the outset of your investigation. Next, physical evidence. So if there is any physical evidence that's relevant to the investigation, it's a good idea to have that ready to go and in the investigator's sort of possession to the extent that can be done prior to getting started with interviews. It's it's not CSI, so, we're probably not talking about fingerprints or, hair strands, DNA testing kind of physical evidence, but you may have, text messages, photographs, handwritten notes. Again, we talked about the personnel file materials. Things like that can be really helpful to, have to be able to show individuals during interviews if it's appropriate, and really just overall, having an overall understanding of all the pieces involved in the allegations going forward. So introducing your investigator, if you are not the investigator yourself. This really applies, again, if you're the one coordinating things, and particularly if it's an outside party or an attorney doing the investigation. It's helpful to make that introduction to the individuals who are going to be interviewed in the course of the investigation. It can be really daunting, as you might imagine, to get an email or a phone call out of the blue from somebody who wants to talk to you about a workplace issue, a potentially uncomfortable workplace issue. And the individual or the employee might not even know whether they should talk to that person if they don't already have that introduction and understand that the investigation is going on. It is okay in some circumstances, depending to, let the investigator coordinate times to meet or things like that. But making that initial introduction is really helpful to building comfort with the process and setting forth expectations. During that introduction, again, if you're not the one investigating, it's a great time to let employees know about your anti-retaliation policy. And that's assuming you have one. If you don't, it's a policy we recommend you have. But basically, it's your policy that they're participating and cooperating with the investigation won't result in any retaliation in the workplace. Retaliation is illegal for this type of cooperation. And they won't be subjected to it. I know a recent investigation I did, just sort of as an example, I was interviewing a complainant, and that individual had specifically asked me, am I going to be fired after this? So, again, that was an opportunity during the investigation to reiterate that no, you won't. This is a protected process, and the things that you say won't result in any retaliation. Another important piece of this as well is to remind people that they should also not be engaging in retaliation. So this can be, you can imagine a situation where you have an employee making a complaint about a manager and you need to interview the managers, as part of the investigation process or help coordinate those interviews. In addition to the fact that they won't be subjected to retaliation, you should remind them that that's the expectation on their behalf as well. And it can be tough, it can be awkward if a manager or supervisor knows that they have an employee that's made a complaint about them. Maybe the employee is still working for the company, but that manager should be reminded to treat that employee exactly the same and not engage in the retaliation that they're also protected from. So another thing you want to think about is document preservation, particularly with respect to electronic documents. That's where most things live these days, and it's also really easy for electronic documentation to disappear, not purposely or purposely. So if any of you have been involved in litigation, you know about that discovery process that we've referenced, where parties exchange documents that are relevant to the issues. And parties can be subject to sanctions if it comes out that they had relevant documents, and those documents or emails had been destroyed, whether accidentally or on purpose, after they knew about the prospect of the lawsuit. So even at the investigation phase, it's a good idea to make sure that relevant information isn't being deleted or destroyed. Getting in touch with your IT department is a good first step, making sure that automatic email deletion is turned off for people involved if you have that type of system active. It's a good idea to let people who are involved know, or who may have relevant documents, know that they shouldn't be deleting relevant emails with a complainant or that might relate to the situation during the course of the investigation. And in many cases, especially if we know that litigation is coming or suspect it, we recommend sending a letter or sending a more formal email to people involved to outline those expectations for preservation and procedures for maintaining documents. So Also consider what other interim measures might be necessary. This really depends on the circumstances. One of the questions you might ask is, should we suspend the person who's subject to the investigation? Certainly if there's a risk of any physical harm or ongoing, sort of mental harm to other employees or the complainant in the particular case, if the subject employee is going to cause issues for the company and operations, a suspension might be something you consider. It could be paid or unpaid, but you'll want to check with your policies and see whether you have a disciplinary policy that governs a suspension, or also consider how that situation has been handled in the past to make sure you're staying consistent with your disciplinary procedures. Maybe a suspension isn't warranted, but you might want to direct a subject not to communicate with certain individuals, particularly if there was a harassment or discrimination issue going on. Again, it really depends on the individual and the situation, but it's a good idea to consider how you can protect your organization during the course of the investigation. So let's talk about interviews. And we'll talk a little bit about strategies. So a big consideration here in investigation is which order to interview people. It's not uncommon to start with the complainant. If there is a particular complainant in a case, is probably what resulted in the investigation starting, and could be a good way to sort of get bearings on the allegations of what's happened. But it is worth stepping back and thinking about the circumstances and the allegations, who's involved, to see whether it makes sense to start with somebody else. As sort of as an example, if you have like a workplace theft issue or something like that, it might make sense to start with third parties, the people who noticed that things were missing, or who are doing inventories to sort of help get that big picture idea of what happened, particularly before you talk to the individual who's actually accused. And to that end, think about when it's a good time to interview the person actually accused. Do you want to interview everybody else, witnesses, complainant first, get the full, that side of the story first, or get both parties who are involved sides and then get witness accounts to sort of fill in the gaps? Again, it depends on the situation and also availability of witnesses as well. So one thing to keep in mind as well throughout the process is, again, I mentioned this, it's probably pretty uncomfortable for most of the people who are going to be involved interview-wise, especially if it's a harassment or a discrimination issue. Nobody likes telling their work colleagues about the crude jokes or the remarks that embarrassed or offended them. They don't like explaining about inappropriate touching they've experienced at work. Some of these situations that are resulting in an investigation are just going to be a little bit ugly, a little bit uncomfortable. So even witnesses who might not have been subjected to particular behavior, they might be fearful of participating. They don't want to get in trouble. They don't want to get their colleagues in trouble. So it can be intimidating to have that conversation. It's again why it's so important to stress that they're not going to be retaliated against for participating in the process, which hopefully helps alleviate some of those fears. Finally, just another general interview point, it's worth thinking about who else might be involved in the interview process. It's possible that somebody accused of misconduct might want a lawyer present with them, which, frankly, could be telling in terms of their intent to pursue litigation down the road, depending on how that ends up. If your organization has or is subject to a collective bargaining agreement, it might be appropriate for a union rep to be present. If somebody's experienced harassment or discrimination in the workplace, they might ask to have a support person there, like a counselor. So generally, again, you should still proceed with the interview, but it's all the more important that you do think about who the audience is for the interview. Make sure that you're well prepared for that, particularly if there is going to be a lawyer present. So let's talk about some interview techniques. How should you memorialize the interview? You're going through this whole process, right? Taking interviews during the course of the investigation, but the value is really limited without good notes. It also makes it really difficult to write a report at the end without notes or documentation of your interview. So a lot of folks like to take notes, and that can be a really effective technique depending on the interviewer and their note-taking skills. They need to be able to synthesize what's being said and make sure they're getting big points. But there is, of course, a potential for missing out on details. It might be hard to write down quotes. So, there are some considerations to take into account there. Typing notes is also an option. If the interview is a fast typer, you can get a lot more information down, but it can be awkward to have a laptop screen on the table between the two of you. So it's really a degree of personal preference. But the goal is really to make sure that you're getting an accurate and complete accounting of what the witness is relaying. Another option might be to have somebody sit in and take notes, depending on the circumstances, but that way the interviewer can really focus on the questions that are being asked and the interview itself, and don't need to worry about losing their train of thought from trying to write everything down. And recording can be another good option. If you are planning to record or want to record, be aware of what the state law is regarding recordings. Some states require the consent of both parties to the recording before the recording can be legal. In Maine, it only requires the consent of one party. So if the interviewer consents, then that meets the consent requirement. But in practice, at least my opinion is it's generally a good idea to disclose that you're recording. It avoids issues with the other person finding out that you're recording, which can create some anxiety and also mistrust for the interviewer in the process. And they are aware of the recording and can speak to it when or if they ever need to, use that recording in the future going forward. It's also a really accurate way to make sure that everything is memorialized. There is, of course, a concern, well, people don't like being recorded, right? And it might stifle the conversation, but with the right approach, the interviewer can frame it as, wanting to make sure that they can fully participate in the interview, make sure they get everything right that they're saying, and sort of avoid some of those concerns. If you do record, you should consider whether you'll provide a copy of either the recording or the transcript to the witness. It can also, be a way to, again, help incentivize the recording so that they feel like they'll have an opportunity to review it and make sure it's accurate before being used. So some other things to keep in mind during questioning. It's a good idea to ask the witness who else they think you should interview. Ultimately, it's a fact-finding mission. So it's a helpful tip to ask, who else do you think I should talk to? And that really gives your interviewer an opportunity to assess their understanding of who's involved and what happened. They also might learn about new witnesses or new connections, and that really helps get a fuller picture of the situation. It's also important for the interviewer to emphasize confidentiality and, frankly, the potential lack thereof. Most people will expect a level of confidentiality given the fears that we've talked about in participating, but it's hard to guarantee that in the course of an investigation because it may be necessary to share some information with people who need to know and who are going to read the report. So to that end, it's important to let witnesses know that confidentiality will be maintained to the extent possible, but it may need to be utilized on a need-to-know basis. And again, to this point, I think it's also important to let witnesses know and interviewees know that they should also be respectful of confidentiality throughout the process. We don't want to run any issues with saying they can't speak about things because of National Labor Relations Act issues, but one way I like to frame it is just asking them to be respectful of that process and imagine how they would want to be treated if they were the person who had made a complaint. How would they want that to be treated confidentiality-wise? Lastly, it's a great idea to provide the contact information of the interviewer to the witnesses to let them know that they can follow up with additional information. We all have been there where you're just laying in bed at 3 o'clock in the morning and something pops in your head and you think you should have brought it up. So it's a good idea to give witnesses the opportunity to get in touch with the interviewer if they have one of those moments. So some more interview techniques. First, sort of intuitive, but interviews are generally one-on-one and private. We're not going to a coffee shop. You're not going to be sitting in the break room during the lunch hour. It's important that witnesses have privacy to discuss the issues that are involved without others hearing what's going on, both, for comfort level and to protect those confidentiality concerns that we were talking about. Two, come with a script, but be prepared to go in other places. Erik talked about some of this in terms of preparing your, what the issues that you want to address. And it's a great idea to go in with at least a list of topics that you intend to address to make sure that you're hitting those issues and staying on track. But your interviewers should have the flexibility to deviate depending on what comes up. If you're asking about an interaction between some coworkers that happened last week, and they go, your witness might say, well, yeah, I remember seeing that, but it was, nothing compared to what happened between the two of them a few weeks ago. That, is something you should be able to follow up on and have some flexibility in your interview technique. Asking open-ended questions is also a great way to, again, help with the fact-finding goals of the interview. So when we talk about open-ended questions, it's really easy to sort of pre-fill your questions with answers in a way that they become yes or no questions that reflect what the asker expects to hear or wants to hear. We call these leading questions, sort of in the legal field. And if anybody's seen a courtroom drama, it's those, tight, tense moments where somebody's on the stand and the lawyer is asking those really long-winded, targeted questions to try and pin a witness. Works great in that setting, but that is not the goal with an investigative interview. You want to give the witness as much opportunity and space to tell you about what happened and provide information. So try to avoid those close-ended questions that sort of presuppose an answer. And lastly here, closeout questions are something that can be a little tricky, but it's great to prepare for. So, again, the goal here is to get as complete of a story as possible. So it's great practice to ask a witness, is there anything else that you think I should know? And that opens the door to more information that you might not have specifically asked about. Another question that I like to ask is, is there anything that you thought I would ask about but didn't ask about? And you might get something crazy like, oh yeah, I really thought you were going to ask about that wild work party that we had last year where, everybody was drinking and so had this interaction. That might have nothing to do with the interview. Maybe you don't want to know about it, but in some cases it might yield information that should be followed up on and might be relevant that the investigator just didn't know going into it. Specifically for the complainant as well, it's good to sort of ask a question, have you told me everything? Is there anything else that I haven't brought up? And that allows them to give a more affirmative, again, closure to the interview and make sure that all allegations are at the forefront and being addressed at the outset, rather than a situation where later, they're like, oh, well, yeah, there were more things that I wanted to tell you. I just didn't have the opportunity to, or you didn't ask. So almost done with interview techniques, but this is an important one. So, again, this isn't an interrogation. It's important for the interviewer to build a rapport with the interviewee. Again, despite the fact it's an uncomfortable situation, it also doesn't mean that the investigator and the witness need to be best friends at the end of it. They're not going to go get coffee and hang out and go to a movie. But ideally, the interviewer is going to be able to build up enough of a relationship or a rapport with the witness that they feel comfortable talking to them and sharing details. And one way to do this is really by anticipating what the witness might need during the interview. So, it's those little things like reminding them, hey, you can take a break if you need to, just let me know. Maybe you have a bottle of water ready for them when they come in. Proactively explaining the process, why they're here. Again, those confidentiality concerns, the retaliation policy, all of that can help a witness feel more comfortable with the interviewer without, sort of crossing any lines. Again, remain neutral. So an interviewer really is a neutral party here, and this can be trickier when it's an internal person at the organization doing the interview. But really maintaining a level of neutrality in the questions that are being asked and demeanor is important, and will help the witness feel more comfortable talking and not like they're being judged or accused, or that the interviewer has sort of preconceived notions or expectations about what happened. The goal really, again, is to let the witness talk. We talked about the types of questions to ask, and make sure that the witness has the opportunity to talk as much as they need to be responsive. Avoid interruptions or trying to, cut them off to get to the next question kind of thing. Just leaving a few seconds of silence after questions can be a great way to just make sure that they've communicated everything that needs to be said. Because again, the goal here is really making sure that the witness feels heard, and particularly with complainants. One of the interviews that I've done, the complainant was she relayed multiple times throughout the interview that she felt so grateful that the company was going through this process. And she felt like they were taking it seriously, and she really appreciated the opportunity to share her concerns. And in addition to being a great way to, get the facts of what needs to be investigated, it can also potentially, lower the risk that litigation comes down the road if they feel like the company is taking them seriously and addressing their concerns. With that, I'll flip it back to Erik.
Thank you. Before I go into the last couple topics that we want to cover about witness credibility and writing the investigative report, we've got a question from one of our attendees. We have a practice of asking witnesses to write their own statements. Is this still a good practice? Can you provide an effective alternative should a witness not want to write their statement, such as the interviewer taking notes and asking for approval of the notes from the witness? I'll briefly say how I'll handle that, and Liz, maybe you can give your thoughts on it as well. So I don't think there's anything wrong with having someone write out a statement, but I don't think that that's a substitute for actually interviewing them. I think you asked for an effective alternative. I don't show people my notes. I don't ask people to say, hey, initial here showing that I've written down correctly everything that you want in the situations where I take notes. And certainly if I do a recording, excuse me, you can't do that. What I'll typically do is as I'm going through the interview, I'll ask someone to essentially, hey, have I gotten this right? Okay, so you said that at the office party, you saw Mr. X have 4 or 5 drinks in a row before he went over to the person that complained about, inappropriate touching. Is that right? Yes. And so I'll actually put in my notes if I'm taking, if I'm actually taking notes, I'll put in my notes that, hey, I've had this person corroborate it. If I'm doing a recording, it'll be on there that the person has corroborated it. And that's also an effective way to have the person say, yeah, and I remember that because X, Y, and Z, or, well, yeah, it was 4 or 5 drinks, but I didn't see whether they were alcoholic, something like that. It again, as Liz indicated, what you're really trying to do here is build rapport, get people talking. And so I feel like it's more effective to communicate with them one-on-one as opposed to just relying on a writing. And I can kind of understand why you would want to do that from a cost and time perspective. But even when you've got a situation, I mentioned this case that I had where I did a ton of witness interviews. A lot of them were quick and over the phone. They weren't all like 2 and 3 hour ones. So you can, a lot of your witnesses are not somebody who's going to know everything from A to Z. They're there to talk about very discrete topics. So you can conduct interviews of the style that I just kind of mentioned relatively briefly and relatively cost effectively.
Yeah, I definitely agree. And I've utilized that similar approach to Erik with sort of relaying the information back to confirm. And the only other thing I'd add is with respect to witness statements is that sometimes, I agree it's not a substitution for an interview, because sometimes people don't know what they should know or what they think they know. They might know more than they think is relevant. And so that's the goal of a good investigator, is to help tease that out from what the witness might initially think is sort of the end of the story or the end of the relevant facts.
One. All right, I want to cover the last two topics and be sensitive to people's time because we are coming up on the hour limit that we said that this webinar would last. So witness credibility, it's the investigator's job to determine it. I mean, when Liz and I are hired to conduct an external investigation, people are asking us to come up with the conclusion of what happened. And so part of determining what happened is, why do you feel that that's what happened? And so there will be conflicting statements. There will be conflicting evidence. Both in litigation and in investigations, I've almost never, I can't really think of any examples of people saying, yep, I sexually harassed that person, or yep, I discriminated against that person on the basis of their race. So there will be that conflicting evidence and those conflicting statements. How do you determine who's more credible? Here's a couple of bullet points to look at. Is it plausible? Does it make sense what a witness is saying? Or does it seem like this is not something that would happen in the real world, or it just doesn't sit right with you? Corroboration. Has something that the witness said been corroborated by other witnesses or documentary evidence, especially, is very powerful. Does the witness have a motive to say what they're saying, or do they lack any motive to say what they're saying, which therefore makes them more credible? Hey, I don't have a dog in this fight. I don't report to so-and-so, he doesn't have any power over my job. So when I say that I never saw him sexually harass or say anything inappropriate or touch anybody inappropriately, it's not like, I have an incentive to back up his position. And demeanor. It's a little bit more difficult now that we do a lot of interviews by Zoom. But the type of stuff, is someone really nervous, and beyond the nervousness that comes from talking to an attorney, participating in an investigation, stuff like that. Do they seem jumpy? That kind of stuff. The things that we look at in the real world about whether we think there's something a little bit off here. And then the last thing we want to cover is the investigative report. Is there going to be one? As I mentioned, most investigations of any size, there is one. Again, if you're an attorney that's doing one of these, you assume that there's no attorney-client privilege, especially if you're in one of these Eller-Ferrier situations that Liz mentioned, because you can't say, oh, I created this great, you complained, we did this great investigation with this awesome report, but you can't see it because our attorneys did it. It doesn't work that way. If you're going to try to assert the defense based on an investigative report, generally speaking, you have to produce the report. I have a template that I use, but when I do these things, but I start off by doing it. It's really what will be most understandable and most comprehensible. I mentioned scope creep earlier. Again, that's something you want to avoid. I often will put in, hey, so-and-so talked about these other things. I didn't view that as relevant to my charge. Therefore, while I'm mentioning it here, I didn't look at it any further. Obviously, you want to talk about why you reached your conclusions by citing key documents, key evidence, key witness statements, especially. And remember that when you're writing these things, a lot of times you're going to have a bunch of different audiences. The employer, who often retains Liz and I to do these types of things. The employee, the accuser, their lawyers, they often get copies of them. If there's a Maine Human Rights Commission investigation, a lot of times that'll become part of the record. And if the case goes into suit, a judge or jury might be looking at it as well. That brings us to one more. Again, these are all, I think, sort of common sense stuff, but these are points that make your report more readable. Assume that the audience doesn't know anything about it, so give them a brief introduction. Write plainly. Lawyers are notoriously wordy and use a lot of jargon. You don't want to do that. Any factual conclusions, you want to explain. What are the facts that form the basis for your conclusion, and why you reached certain conclusions regarding credibility. A key one there is the next to last bullet point. There's always conflicting evidence. You need to acknowledge that. Even though I found X, so-and-so said Y, you need to report that. It makes your report more credible and more thorough, and it helps achieve the goal that we talked about at the beginning and now here at the end, by acknowledging that there is conflicting evidence in the record. So anyway, if you do all of this stuff, hopefully you will reach the goal that we talked about at the beginning and at the end. Before we let you go, there are two other questions. Somebody asked, why one-on-one interviews? we have a practice of at least 2 interviewers present to avoid he said, she said situations. What are pluses and negatives? Pluses to one-on-one are, I think it's easier to build rapport when it's one-on-one and you don't have somebody else in the room. Liz talked about how uncomfortable a lot of people are when they're involved in this process. I think if you've got somebody else in the room, that it hurts the vibe. It hurts building rapport. Liz, I don't know if you feel similarly or differently.
Yeah, I think that's a risk, especially if it's 2 folks from the company. It might feel a little bit like they are being ganged up on, or are outnumbered in the room. And that just weighs against rapport. So rapport is often, again, I agree with Eric, easier to build in a one-on-one situation. That said, there are situations when I think it might make sense to have 2 people in a room, more so outside of this investigation interviewer context. When we're talking about, a termination conversation or something like that, it's, important to have that protection against a he said, she said. But in the interview context, again, this is why you have to really evaluate what a good note-taking system is and a good way to get down the information that needs to get down, so that you might not need that second person to avoid the issue. And that's one benefit of recording.
Yep, that's a good point. The next question we have: if an employee asked for another employee to sit as their witness, can an employer deny this? I think if I'm understanding the question, it's can an employee suggest that someone that, if you're the interviewer, that you talk to somebody else? If that's the case, I'll always say, yeah, I'll talk to somebody. I feel like it helps build my credibility as an investigator, helps show that I'm objective. Hey, you told me I should talk to so-and-so about what's going on. I want to do that. Could you do it? Yeah, I suppose you could. I mean, there were, I tell people that in my interviews that the only types of investigations that have an unlimited scope and an unlimited budget are those that are conducted by the federal government. And I don't work for the federal government. So while I tell people, hey, I'm willing to talk to just about anybody, there are times where I'll make the decision there's just not a lot of value. You're just going to say stuff that I've already heard. But if I do that, if I don't talk to somebody affirmatively that someone suggested, I'll make sure that the person who made the suggestion knows that I'm not going to do it and knows why I'm not going to do it.
Yeah. And so to the extent that this is asking, like, can you ask can an employee have a coworker sit in with them during the employee's interview? My answer would generally be no. Purely because, well, and again, it really depends, but one of the big risks of having more than one employee in an interview would be sort of tainting the credibility of that other person as a witness. So if you need that other person to, be interviewed at some point, then, and they hear everything that the employee has already said, then it's sort of, I guess you have people hearing what each other are saying. And so it can, I think, reduce credibility to a degree. If they were, to the extent that they're trying to reflect that it's their original knowledge. That makes sense. Yeah. So if you have 2 parties who are involved, you might want to do it separately.
Good point. And one other thing on that, if you're in a unionized setting, the answer may be different, because you may have a co-employee, for example, who's the shop steward, who is actually the representative of the employee who's being interviewed and is sort of effectively the advocate in that type of situation. All right.
Oh, sorry. I was just going to add one more really quick point. If you do have a situation where, people are very insistent and more than one person wants to be in the room, it is something you could note and should note in an investigative report, so that, the person interpreting the report can consider that as a credibility issue later.
Yep. Good point. Last question that we have: can an employer ask if an employee is recording an interview? Yes. You can certainly ask. I will say, especially since I do a lot of interviews by Zoom, and there's the recording feature, but also, everybody has a cell phone nowadays and can record you that way. I will always ask, and I frankly don't care if people are recording what I'm doing. I mean, there's nothing that I would want to ask or nothing that I would say that I wouldn't, you know, I view it as almost like when I'm in a deposition or I'm in court. I shouldn't be saying anything. I shouldn't be asking any questions that I wouldn't want the general public to hear anyway. So that doesn't bother me. One thing that I will say, and so I typically do ask people if they are recording, and I almost, whether they're telling the truth or not, people invariably say that they are not. And so I will go on to say, hey, it doesn't matter to me if you do or not. But the one thing that I will tell you is this concerns a sensitive personnel matter. And under Maine law and under the law of a lot of states, employers have a duty to maintain confidentiality regarding personnel matters. And so I'll say to the person, I'll tell the person about that obligation that the employer has, and I'll say, go ahead and record it if you want, but please, don't disseminate it, don't make it public or anything like that, because that makes it impossible for us to fulfill the duty that we have. And then I've gotten on the record, I don't care if you record it, and if you are going to record it, don't put it out on Facebook or something like that.
Yeah, and the only thing I would add to that is that again, in this day and age with the ability to record just about anything on a phone with or without your knowledge, it's a really good reason why you should have a skilled investigator or somebody who is not going to be potentially an issue on that recording down the line if that was ever to be disseminated or needed or used. So it's a good idea to make sure that the interviewers are trained and know they might be recorded.
All right. Well, thank you everyone for your time, for sticking with us. I know we went a little bit over. If any of you have any questions or any follow-up or anything like that, you will be getting, as I said at the beginning of this, you'll be getting an audio recording of the webinar along with the slides. Our contact information is on the first slide. Please feel free to reach out to us, and thank you again for your time.
Thank you.